Now, I'd like to invite His Excellency PAIK Jin Hyun, former President of the International Tribunal for the Law of the Sea, to the stage. He's now here with us to deliver a keynote speech. So Judge PAIK, thank you for coming up to the stage. Please give a big round of applause.
Vice Foreign Minister Oh, President Haida, President Kang, dear colleagues. It is a great honor for me to deliver a keynote speech in the annual International Conference on the Law of the Sea, hosted by Ministry of Foreign Affairs of Korea in cooperation with Korean Society of International Law and the International Tribunal for the Law of the Sea. I want to thank the organizers for a kind invitation. This year's conference is the 8th of those which Korean Foreign Ministry and ICLS have been jointly organizing annually since 2016. Over the past 7 years, the Korea-ICLS conference has emerged as one of the most important events in the field of the law of the sea, attended by renowned scholars and practitioners around the world, and addressing topical issues of the time. It has provided us with an opportunity to discuss pressing issues facing the world's oceans today. The theme of this year's conference cannot be more timely. On 19 June 2023, the further resumed fifth session of the Intergovernmental Conference adopted by consensus agreement under the UN Convention on the Law of the Sea on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction. I will refer to it as a BBNJ agreement. This was the culmination of the long and arduous process spanning almost 2 decades since 2004. On the occasion of the adoption of the BBNJ agreement, the UN Secretary General Antonio Guterres stated that, I quote, "The new agreement pumps new life in the ocean at a critical time where it is threatened by climate change, biodiversity loss, and pollution. This historic achievement is a testimony to the strength of multilateralism." End of quote. Indeed, the new BBNJ agreement may be much more than implementing a few provisions of the UN Convention on the Law of the Sea. It has a potential to bring about fundamental changes in the way the high seas are used and protected. In addition, the adoption of the agreement is an encouraging news coming at a time of great challenge to the rules-based international order and dwindling faith in the role of international law and institution in managing international affairs. Today, I want to share with you my thoughts on the significance of BBNJ agreement in the context of the evolution of the high sea governance. If time allows, I will also touch upon the challenges ahead to the effective implementation of the new agreement. Before doing so, however, let me briefly recollect the background of the BBNJ agreement and highlight its main features. The conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction has been attracting international attention as scientific information reveals the richness and vulnerability of such biodiversity. At the same time, concerns have grown about the increasing anthropogenic pressures posed by existing and emerging activities such as fishing, mining, marine pollution, and bioprospecting in the deep sea areas. While UNCLOS is widely acknowledged as establishing the legal framework for all activities in the ocean, the convention adopted more than 4 decades ago does not refer expressly to marine biodiversity. On the other hand, the Convention on Biological Diversity, CBD, which entered into force 3 decades ago, defines biodiversity and aims to promote its conservation, the sustainable use of its components, and the fair and equitable sharing of the benefits arising out of the utilization of genetic resources. However, the CBD applies to process and activities carried out under the jurisdiction or control of a contracting party, and in case of components of biological diversity in areas within the limits of national jurisdiction. As a result, many, if not all, states felt that legal or regulatory gaps existed and that there was a need to start the process for a new agreement to fill gaps in UNCLOS. Eventually, following more than a decade of informal discussions, and 4 sessions of preparatory committee, the UN General Assembly, in its resolution 72/249 of December 2017, decided to convene an intergovernmental conference to elaborate the text of an internationally legally binding instrument on the UNCLOS on the conservation and sustainable use of biodiversity beyond national jurisdiction. The negotiations addressed 4 main topics intended as a package in the sense that they should be addressed together and as a whole. Of course, the 4 main topics are the subjects of this conference and will be discussed in the subsequent sessions. After 5 rounds of negotiation over the period of 5 years, the Intergovernmental Conference finally adopted by consensus the BBNJ agreement. As the new agreement will be scrutinized by many experts in the subsequent sessions, it would not be necessary for me to go through them in details. Instead, I will just highlight its key features. The BBNJ agreement is composed of preamble, the text divided into 12 parts and 76 articles, and 2 annexes. Part 1 defines some key terms used in the agreement and addresses its objects and scope of application. I note that according to Article 1, Paragraph 2, the term areas beyond national jurisdiction means the high seas and the area, namely the seabed and ocean floor and subsoil thereof beyond the limits of national jurisdiction. I will come back to this later. Part 1 also clarifies the relationship between BBNJ agreement on the one hand and UNCLOS, relevant legal instruments and frameworks, and relevant bodies on the other. In particular, Article 5, Paragraph 2 provides that, I quote, "This agreement shall be interpreted and applied in a manner that does not undermine relevant legal instruments and frameworks and relevant global, regional, sub-regional, and sectoral bodies, and that promotes coherence and coordination with those instruments, frameworks, and bodies." End of quote. Many commentators expect that this provision will be one of the key elements to the effective implementation of the BBNJ agreement. In addition, Part 1 spells out the general principles and approaches which shall guide parties in order to achieve the objectives of the agreement. As such principles, Article 7 refers, inter alia, the principle of common heritage of humankind, which is set out in UNCLOS, and the freedom of marine scientific research, together with other freedoms of the high seas. Part 2 contains provisions on marine genetic resources, MGRs, including the fair and equitable sharing of benefits. This provision aims to equitably share benefits arising from activities with respect to MGRs and digital sequence information, DSI, for the conservation and sustainable use of BBNJ, and to build and develop relevant capacities of parties, particularly developing states parties. Part 3 aims to establish a comprehensive system of area-based management tools, ABMTs, with ecologically representative and well-connected networks of marine protected areas, MPAs. It also aims to strengthen regional and international cooperation towards preserving and restoring marine biodiversity and fragile ecosystem. Part 5 operationalizes Articles 205 and 206 of UNCLOS on Environmental Impact Assessment, EIA, for areas beyond national jurisdiction. For this end, it establishes process, thresholds, and other requirements for conducting and reporting EIAs by parties, and ensures that such assessments are conducted to prevent, mitigate, and manage significant adverse impacts for the purpose of protecting and preserving the marine environment. Part 5 focuses on capacity building and transfer of marine technologies. It aims to assist parties, in particular developing states parties, to develop their scientific and technological capacity towards conservation and sustainable use of BBNJ, and to assist them in implementing the provisions of the new agreement. Remaining provisions address, among others, institutional arrangements, financial resources and mechanism, implementation and compliance, and settlement of disputes. In particular, the institutional arrangement will lead to the establishment of a number of bodies, including the Conference of the Parties, the Scientific and Technical Body, and the Secretariat. Dear colleagues, now let me turn to the main part of my speech and address the significance of the BBNJ agreement in the context of the evolution of the high seas governance. The regime of the high seas is as old as the law of sea itself. Most of the world's oceans and seas used to be the high seas until the middle of the last century, and the expression, the freedom of the seas rather than the freedom of the high seas, was a more or less accurate description of the legal regime of the oceans. However, huge changes have taken place to the high seas governance. As a result of the expansion of the coastal state jurisdiction, which began in earnest after the end of the Second World War, substantial portion of what had been the high sea have fallen under exclusive national jurisdiction in which coastal states exercises sovereignty or sovereign rights. In addition, more and more regulation over activities on the high sea have been introduced for various purposes, ranging from the conservation of living resources to ensuring navigational safety, to prevention of pollution and protection of the marine environment, and to exploration and exploitation of seabed resources. Then what is the current legal state of the high seas? How the high seas are governed today? Let me first draw your attention to the geographical scope of the high seas. Contrary to what many of you may assume, the geographical scope of the high sea is not entirely clear, especially with respect to the seabed and subsoil. The question of geographical scope entails implication for rules governing high seas activities, in particular activities in the seabed and subsoil. Article 86 of UNCLOS, which is the first article of Part 7 on the high seas, stipulates that, I quote, "The provisions of this part apply to all parts of the sea that are not included in the exclusive economic zone, in the territorial sea, or in the internal waters of state, or in the archipelagic waters of an archipelagic state." End of quote. Unlike Article 1 of 1958 High Seas Convention, this article does not define the high seas, but rather provides for the application of the provisions of Part 7. You may recall that there is a long story behind such formulation, which was a product of compromise relating to controversy over the legal status of the exclusive economic zone at the Third UN Conference on the Law of the Sea. In any case, all parts of the sea may ordinarily be understood to encompass not only water column, but also the seabed and subsoil. Furthermore, Article 87, Paragraph 1 of UNCLOS enumerates the freedom of the high seas, including freedom to lay submarine cables and pipelines, freedom to construct artificial islands and other installations, and freedom of scientific research, which clearly apply to the seabed and subsoil. If this understanding is correct, the high seas provision of Part 7 apply to the seabed and subsoil beyond the exclusive economic zone, as well as superadjacent water column. Of course, this does not mean that all freedoms and uses of the high sea shall apply to the seabed and subsoil of the high seas. Needless to say, the exploration and exploitation of natural resources of the continental shelf are subject to Part 5 of the Convention, and activities in the area shall be governed by Part 11 of the Convention. At this stage, let me take a quick look at 1958 Convention on the High Seas, just to make sure. Article 1 of 1958 Convention, which is considered to have codified customary rules of international law relating to the high sea, as stated in preamble, states, I quote, "The term high sea means all parts of the sea that are not included in the territorial sea or in the internal waters of state." End of quote. It should be noted that this convention was adopted together with the Convention on the Continental Shelf. The absence of reference to the continental shelf in the definition of high sea appears to suggest that continental shelf is not excluded in the geographical scope of the high sea unless all parts of the sea is confined to the water columns only. However, such interpretation does not seem to be very convincing in light of the ordinary meaning of all parts of the sea. Again, it is clear that not all freedoms of the high sea apply to the continental shelf. On the contrary, coastal state exercises over the continental shelf sovereign rights for the purpose of exploring it and exploiting its natural resources. Accordingly, I think that provisions of the high seas under Part 7 of UNCLOS apply not only to the water column, but to the seabed and subsoil, of course subject to relevant provisions of the Convention. The latest edition of the Law of the Sea by Churchill, Lowe, and Sander states that the legal concept of the high seas extends, I quote, to the seabed and subsoil subject, in the case of outer continental shelf beyond the exclusive economic zone, to the coastal state's sovereign rights to explore and exploit its resources, and in the case of activities to explore and exploit the resources of the area, to the provisions of Part 11 of UNCLOS. This is a very careful formulation. Similarly, it has been suggested that the regime of the area is not a self-contained regime, but builds upon the regime of the high seas, in respect of which it can be seen as lex specialis. As such, according to this view, when rules set out for the regime of the area do not apply, the general rules on the high seas do. At this stage, may I draw your attention to Article 1, Paragraph 2 of the BBNJ Agreement, which provides that for the purpose of this agreement, areas beyond national jurisdiction means the high seas and the area. It appears that for the purpose of BBNJ agreement, the area, namely the seabed and subsoil beyond national jurisdiction, is not included in the high sea. However, it is doubtful that this provision redefines the geographical scope of the high seas or the scope of application of the high seas provisions of UNCLOS. Dear colleagues, now let me turn to the legal status of the high seas. Article 87, paragraph 1 of UNCLOS states, I quote, "The high seas are open to all states, whether coastal or landlocked. Freedom of the high seas is exercised under the condition laid down by the Convention and by other rules of international law." End of quote. It then enumerates 6 such freedoms. It is generally understood that this list is not exhaustive. Paragraph 2 of the same article sets out that, I quote, "These freedoms shall be exercised by all states with due regard to the interests of other states in their exercise of the freedom of the high seas, and also with regard to rights under this convention with respect to activities in the area." End of quote. You may recall in this regard that Article 87 and the legal nature of the high seas was clarified by International Tribunal for the Law of Sea in the MV North Star case. According to Tribunal, I quote, "Article 87 of the Convention proclaims that high seas are open to all states. It also proclaims the freedom of the high seas and provides for the obligation of due regard in its exercise." End of quote. The Tribunal continues, I quote, "The legal status of high seas has a number of implications. As the high seas are open to all states, no part thereof is subject to sovereignty of any state. This notion is laid down in Article 89 of the Convention." The Tribunal further notes that another corollary of the open and free status of the high sea is that, save in exceptional cases, no state may exercise jurisdiction over a foreign ship on the high seas. This principle is clearly reflected in Article 92 of the Convention. The Tribunal thus considered that the notion of the invalidity of claims of sovereignty over the high seas and of exclusive flag state jurisdiction on the high seas are inherent in the legal status of the high seas being open and free. The open and free nature of the high seas, however, also raises some fundamental challenge in terms of attaining public order in that areas. It is not difficult to imagine that without some sorts of ground rules or regulations, multiple and potentially conflicting uses of the high sea can easily lead to serious disorder and instability, and unlimited exercise of freedom would degrade the quality of the high seas as global commons. When the uses of the high seas were confined to the limited incidents of navigation and fishing, the obligation of due regard would have been sufficient. However, with the multiplication and intensification of the high seas uses and the concomitant decline of the state of the high seas and their resources, more substantive regulations and constraints were inevitable. In addition, the desire of a fair and equitable sharing of the resources of the high seas added a new dimension to the traditional notion of the high seas governance. This would then raise several questions. What sort of regulation would be most appropriate in responding to a particular question at hand? If such regulations are negotiated and agreed, how to make states to accept them? And how such regulation can be effectively enforced given the principle of exclusive flag state jurisdiction on the high seas? These are the questions the international community has had to tackle in addressing challenges to the regime of high seas. Some of these questions apply equally to the BBNJ agreement. In the modern law of the sea, freedom of the high seas has never been absolute or unlimited. As I have already mentioned, freedom of the high sea is exercised under the condition laid down by the Convention and by other rules of international law, and shall be exercised by all states with due regard, obligation. The conditions laid down by the Convention to this effect are numerous. For example, Article 94 of the Convention requires every state to effectively exercise its jurisdiction and control in administrative, technical, and social matters over ships flying its flag. Article 192 of the Convention requires states to protect and preserve the marine environment, thus significantly qualifying the freedom of the high seas. Indeed, Part 12 on the protection and preservation of marine environment as a whole applies to the high seas. In addition to the Convention, there are numerous instruments, global and regional, to lay down various conditions to the high seas activities to protect the marine environment. As for the freedom of fishing, Part 7 itself includes a duty of conservation and management of the living resources of the high seas. Thus, the right to fish on the high seas is subject to the duty to take such measure as may be necessary for the conservation of the living resources of the high seas. In addition, states have the obligation to cooperate with each other in the conservation and management of living resources in the areas of the high seas. Such cooperation usually takes place through sub-regional or regional fisheries management organization or arrangements, RFMOs. The UN Fish Stocks Agreement, the second implementing agreement on the UNCLOS, further elaborates the international regulation of the living resources of the high seas with respect to straddling and highly migratory fish stocks. The Fish Stocks Agreement does not set up its own institution, but rather utilizes for various purposes of its provisions institutions that already exist or may be established, namely RFMOs. For the exploration and exploitation of the area, the Convention introduces the new principle and regime embodied in Part 11. Article 136 of UNCLOS proclaims that the area and its resources are the common heritage of mankind. The principle of the common heritage of mankind is considered to be one of the most important achievements of UNCLOS. Part 11 and Annexes 3 and 4 of the Convention, as well as 1994 Implementing Agreement, elaborates and give effect to the notion of the common heritage. Obviously, the regime and institutional arrangements concerning the area and its resources under Part 11 are highly centralized. Be that as it may, however, I do not think that the regime of the area is fundamentally different from other negotiated regulation of activities on the high sea. What is new in Part 11 and the notion of the common heritage of mankind? The real difference between this notion and the traditional regime of the high sea, as it were, is not the regulation of activities per se, which has been the integral part of the high seas regime, but the notion of the benefit of mankind as enshrined in Article 140, paragraph 1 of UNCLOS. This provision states that, I quote, activities in the area shall be carried out for the benefit of mankind as a whole, irrespective of geographical location of states, and taking into particular consideration the interests and needs of developing states. End of quote. It should further be noted that the notion of the benefit of mankind as a whole is not confined to the activities in the area. Article 143 on marine scientific research in the area and Article 140 on archaeological and historical objects also refer to the benefit of mankind as a whole. Accordingly, I'm not convinced by a strict dichotomy between the regime of the common heritage and that of high seas. Nor am I sure that it is correct to say that the regime of common heritage has replaced that of the high seas with respect to the area. The conflict between common heritage and the high seas, as has been seen in the early stage of the BBNJ discussions, may therefore a little bit misleading. There is no reason why the common heritage principle cannot coexist with some, if not all, of principles and freedom of the high seas. In this regard, I note that Article 7 of the BBNJ agreement refers to both principle of common heritage of humankind and the freedom of marine scientific research, together with other freedoms of the high seas, as guiding principle to achieve its objectives. Indeed, the elements of both principles are reflected in the BBNJ agreement. Today, high sea governance is a complex network of principles and regimes. There is a general regime of the high seas with principles inter alia of open access and freedom, the invalidity of claims of sovereignty over the high seas, and exclusive flag state jurisdiction. It should be noted that high seas freedoms are conditioned by the Convention and other rules of international law. There are extensive sets of conditions and restrictions to this effect, and they continue to expand as new needs and circumstances arise. In addition, there are special regimes modifying and complementing the general regime, such as the regime of the area and the regime concerning straddling and highly migratory species. The BBNJ agreement is the latest addition to the regulation of high sea activities. I'm sure that it may not be the end of such regulation. The scope of the BBNJ agreement is quite far-reaching. It is much more than the regulation of activities with respect to marine genetic resources. It introduces significant change to the way the high seas are used and protected. The new agreement establishes a global regime with a centralized institutional arrangement. As such, cooperation and synergy with the existing bodies and instruments with relevant mandates will be central to the agreement to be successful. This may prove to be quite challenging with the ambiguous formulation of not undermine in Article 5, Paragraph 1, and some other relevant provision of the BBNJ agreement. Dear colleagues, now I have come to the final part of my speech. With the adoption of the new agreement, it is now time to move towards effective implementation. In this regard, there are few things that come to my mind. As I said earlier, once a new regime is negotiated and agreed, the next question is how to make states to accept it. Obviously, for the new BBNJ regime to be effective, it is important that agreement enters into force as soon as possible and that as many states as possible join the new regime. The agreement was open for signature on 20 September 2023, and as of 2 days ago, 83 states have signed it. According to Article 68, the agreement shall enter into force 120 days after the date of the deposit of 60th instrument of ratification, approval, acceptance, or accession. Depending on political will and domestic processes, this may take some time. UNCLOS took 12 years to enter into force, and the UN Fish Stocks Agreement took more than 6 years. However, the BBNJ agreement may not have such luxury as the previous agreements had, given the critical state of the ocean due to the threats posed by climate change, biodiversity loss, and pollution. Perhaps more important than the timing of entry into force is to secure widest possible participation in the new agreement. The question of making states to accept new regulations applicable to the high sea has always been a difficult problem. The absence of major actors in the high seas, including the area, would undermine the effectiveness of the new regime. It will also entail serious financial implications. The next question may be that of enforcement. Here, the principle of exclusive flag state jurisdiction continues to prevail. It remains to be seen whether a new system of implementation and compliance provided for in Part 8 of the agreement, as well as a compulsory procedure for the settlement of dispute provided for in Article 60 would make much difference. Before closing, I just want to remind you that all three implementing agreements under UNCLOS are concerned with activities on the high seas, including the area. This may not be a coincidence, given the legal nature of the high seas being open and free. Such areas can be regulated only through negotiation among states. However, the other side of this development is the lack of international community's attention to activities within national jurisdiction. This is problematic because there is no evidence indicating that resources are better conserved or pollution are better controlled in the area within national jurisdiction than in the area beyond national jurisdiction. Maybe time will come for the international community to face this rather inconvenient reality. Undoubtedly, the global protection of the marine environment and conservation and sustainable use of ocean resources require concerted efforts of all states within and beyond national jurisdiction. This brings me to the end of my speech. I would like to thank you again for an opportunity to be here today, and I look forward to productive discussion that I'm sure will take place during the course of the conference. Thank you for your patience and kind attention.
Judge Paik, thank you for your in-depth keynote speech. Please give Judge Paik a big round of applause once again. Thank you.